welcome. Welcome to this panel on the Andy Warhol Foundation versus Lynn Goldsmith oral arguments in front of the US Supreme Court that happened just a few weeks ago. My name is Tom Maddrey with the American Society of Media Photographers, and I'm joined by an incredible panel of attorneys, all of whom worked diligently on this case and on an amicus brief that we jointly wrote. And we're going to get into all of that stuff. But for the moment, I just want to welcome you. We'll let people filter in here from the waiting room. Well, while we are waiting to get started in earnest, let me just say a few things. One, if you're joining us here in the Zoom webinar and you have questions for today, please put those in the Q&A box that you'll see down at the bottom of the screen. It's going to be the easiest way for us to find your questions and answer them. We're going to cover a whole lot of ground today. I think that that oral arguments are some of the most interesting things that go on, certainly in the lifespan of a case. And we got some creative and interesting questions from the justices, as you might imagine. So I'm just going to go ahead and get started. And the way I'm going to start is by asking my colleagues here to introduce themselves. And so let me first throw it over to Mickey from National Press Photographers Association. Mickey.
Thanks. So my name is Mickey Ostreicher. I'm General Counsel of the National Press Photographers Association. I was a photojournalist in both print and broadcast for over 40 years. And even though I spend a lot of time defending and advocating for journalists and their rights to photograph and record, it's just as important to represent their rights to their images, because what good is it if you go out and you risk your health and safety to make these images and then everybody else just gets to use them without properly licensing them. So glad to talk about this and glad to be part of the amicus brief and glad to be with all of you today. So thanks.
Thank you, Mickey. Alicia?
Hi, I'm Alicia Calzada. I'm the Deputy General Counsel for National Press Photographers Association. I also was a photographer for about 20 years before I became an attorney. And like Mickey said, you know, copyright is just really an important part of what we do and what we advocate for, and really, really proud to be able to work on stuff like this and also to help you all understand not just how it affects you and how it's important to you, but, you know, some of the background stuff that these things don't just happen, that there's really a lot going on behind the scenes to protect your rights, and we're privileged to be able to do it.
Thank you, Alicia. Steve?
Thank you. So Steve Doniger, I'm one of the partners of Doniger Burroughs. We're a firm with offices in LA and New York. I serve as counsel, I'm honored to serve as counsel for APA, American Photographic Artists. And my firm has handled cases at the Supreme Court level, certainly plenty of published opinions at the Ninth Circuit and Second Circuit. The majority of our practice deals with copyright litigation, really the enforcement of rights. And, you know, I'm passionate about making sure that the law strikes the right balance of, you know, protecting artists and ensuring that artists have, you know, ample incentive to create and to profit from their work. And you know, that's here speaking to everyone today about the Warhol case. It's an extremely important case that I think you know, can make a big difference in a lot of people's lives.
Well, thank you, Mickey, Alicia, and Steve. And I've had the privilege to work with all three of you for many years now. And again, my name is Thomas Maddrey. I'm General Counsel for ASMP, American Society of Media Photographers, and I also was a photographer for about a decade before I turned my attention to law. And I'm happy to have this opportunity to talk about this case. Lynn Goldsmith has been longtime ASMP member, and ASMP and all of our organizations have been supportive of and interested in this case since it first came up a number of years ago. And so let me start by kind of setting the stage a little bit for what we're going to talk about today. Without going into all the details on how cases work their way through the court system, I will give a brief summary of how this case got up to the US Supreme Court, where it was heard for oral arguments a couple weeks ago. So in the US, in federal court, which is where copyright cases are heard, the first level is what we call the district court level. And that's what we generally think of when we see courts on TV. We see, trials and juries and the back and forth and the evidence. That is certainly for litigators like Steve and his firm, so much a part of the process and what they do. And at the district court level, if your side doesn't prevail, there are avenues that you have to appeal that ruling that the district court judge came up with. And when you go to the next level, it's the Court of Appeals. And in the US, there are many different circuit courts. These are the circuit courts of appeals. And this case was heard in probably one of the two most influential circuit courts, the Second Circuit, which covers the state of New York, among others. And it's in the Second Circuit Court of Appeals where a panel of judges at that court will review the record that occurred at the district court level and then make some findings and determinations about was the case handled correctly on both procedural issues and other things that have been briefed to the court. Now, we wrote an amicus brief with the UCLA School of Law back when this was in front of the Second Circuit Court of Appeals. And at the Second Circuit Court of Appeals, Lynn Goldsmith had appealed the district court finding that held that these uses were fair uses. The Second Circuit Court of Appeals did a detailed analysis in these factors that we're going to look at and talk about here a little bit more, and determine that all of the weight of whether this was fair use or not fair use weighed in Lynn Goldsmith's favor. So they actually reversed, what the district court had held. Now, I don't want to go too far down a side path, but around the same time, there was this case in front of the US Supreme Court. And that case was Google versus Oracle. And Google versus Oracle was also looking at the idea of fair use. And so when this case from the US Supreme Court came out, Google versus Oracle, the Andy Warhol Foundation went back to the Second Circuit Court of Appeals and said, hey, I want you to take another look at this. I want you to reconsider your ruling, the ruling that found that all the factors weighed in Lynn Goldsmith's favor. And I want you to look at it in light of what came out from Google versus Oracle. The Second Circuit actually agreed to reconsider. That's something that is relatively rare. And in that reconsideration, they said that they emphatically disagree that Google versus Oracle had any bearing to change what they had previously ruled. And they again found that all four factors weighed in Lynn Goldsmith's favor. Now, at that point, when you are at the circuit, the circuit courts and the courts of appeals, your only appeal to a higher authority is the US Supreme Court. And that is what the Andy Warhol Foundation did when they filed a petition for the court to hear this case. Now, when you file a petition for the US Supreme Court to hear a case, you have to give them what's known as the question presented. What is the issue that you're asking the court to take a look at? And so in this case, I'm going to read you what the question presented was. And I have a feeling some of some of us may have some thoughts about how this question kind of accurately encapsulates what's going on here. But here's the question that was presented to the US Supreme Court. Whether a work of art is transformative when it conveys a different meaning or message from its source material, as the Supreme Court, US Court of Appeals for the Ninth Circuit, and other courts of appeals have held, or whether a court is forbidden from considering the meaning of the accused work, where it recognizably derives from its source material, as the US Court of Appeals for the Second Circuit has held. So the question here is in those first 5 words, where it says whether a work of art is transformative, and what makes something transformative, right? Before we jump into that, I want to take a broader look at something that you've heard us talk about, and if you've been to, many of the webinars that our various organizations have done, you've heard us talk about amicus briefs and what those are and what those mean and why those are important. And I was thinking maybe, Alicia, do you want to give your thoughts? I know you've written a few this year in addition to this one, and maybe you can tell us what the role of an amicus brief is in the context of what we're discussing.
Yeah, sure. And I feel like this summer was the summer of the amicus briefs. There were just a lot of really important issues before the court that we wanted to weigh in on, and almost like had no choice. We were like, oh, can't do this, but we have no choice. And so I really, thank you to all of you for it was a collective effort. We could not have done it, if it was just one of us trying to do all this. But the job of a lawyer who represents a plaintiff or defendant is to help their plaintiff or defendant win. They have to focus on the facts of the case. They have to focus on the law as it relates to the case, and then, applying the law to the facts in a way that will support the case. And their goal is to win. Their goal is to serve their clients. That doesn't always, and every time when you file an appellate brief in particular, you have page limits. Supreme Court briefs, same thing. When you have limits on what you can talk about, you have to focus on even sometimes very minute details in the case that really do make a difference. And so that's the job of the litigator, the lawyer that represents either the plaintiff or the defendant who's trying to get relief from the appellate court. But they don't necessarily always have time to talk about, what happens if the court rules in a certain way on this particular case. And that's where we come in. What we do with our amicus briefs is not so much, here's the facts of the case and we're going to apply the law. And, it's sort of like a Me Too in our case, the photographer's brief. But what we do is we talk about the impact that this ruling will have on the industry as a whole. So particularly in this case, this was a case where, first of all, really with respect to these kinds of creative works, it's been about 30 years since the Supreme Court, before the Google v. Oracle case, had really addressed fair use. And here they are addressing it with a photography case. And of course, we know that infringement cases related to photographers has just skyrocketed in recent decades. And so, fair use is a very common excuse, defense that people use when they're caught using an image without permission, or, in some cases it really is fair use. But unfortunately, fair use, is a balancing test. And different judges will balance that test differently. So one of the things we advocate for, of course, is let's make sure that they understand the issues and make sure that they rule in a way that's favorable to the industry. Sometimes what we ask for is just, it's so important, particularly on the petition for review stage, it's so important for you to address this and be clear about it, because lack of clarity hurts everybody. Obviously we want clarity that supports photographers, but we also know that the lack of clarity in some cases and in some situations can really be detrimental to both, So it's really, we argue to the courts to support copyright law and interpret it in a way that is good for photographers and for the industry, keeping in mind, of course, that photographers also take advantage of fair use all the time, and so do our clients. And so, you know, we want to balance their interpretation of the law, but we don't want mistakes to be made, and particularly at the level of the Supreme Court. You know, if this goes the wrong way, or if they insert statements that you know, are particularly harmful, it could really leave us in trouble. It could have an impact for decades to come.
Thank you, Alicia. Yeah, I think it's one of the most enjoyable parts of this job, and I look at it a little bit differently on the day-to-day, because I'm not a litigator like Steve is. And Steve, you know, you were recently, you and your firm were recently involved in a case in front of the U.S. Supreme Court that we wrote an amicus brief on separately. Obviously, you were a party to the case, attorney in the case, so you didn't write the amicus brief. But I was wondering if you could tell us a little bit about your experience just having a case in front of the U.S. Supreme Court.
Yeah, having a case in front of the Supreme Court is it's unlike anything else that you can do. There's, you know, courts are bound by authority. They're bound by higher authority. And when you get to the Supreme Court level, there really is no higher authority other than the plain language. I mean, the plain language of the statute. The Supreme Court is going to look at the case and say, okay, does the plain language of the statute answer this question? And generally speaking, when you get up to the Supreme Court level, it doesn't. Because what the Supreme Court is there to do is not address, you know, someone disagrees with the lower court's decision, you know, interpretation of the statute, the Supreme Court's going to review it. That's not what the Supreme Court does. The Supreme Court will generally only take matters up if there's actually a bona fide circuit split, or in very limited cases, if it's a very important question of federal law, you know, that has broad repercussions. But most of the time, you're dealing with cases where there's a circuit split, which means that, you know, well-informed judges at the appellate level, already at the higher level, have disagreed as to what the appropriate interpretation is. And so now the Supreme Court has to take that on. In the case that we won at the Supreme Court earlier this year, we had a significant number of amicus briefs that were filed, you know, on our behalf. I mean, both sides did. And, you know, to Alicia's point, I think she did an excellent job of explaining, you know, why we file amicus briefs. But we do because, and we did in this case, and I filed amicus briefs. I mean, I think I wrote or co-wrote at least 5 amicus briefs so far this year. And in a number of those, we may have agreed with the outcome in one case, but it may have been for a different reason than the litigants, you know, the prevailing litigant. And so we step in to say, you know, we think this is sort of the better approach. You know, as an advocate for my client, I'm going to, you know, I always look at sort of the big picture, but I have to look at what's best for that client, and that's what I'm going to advocate for. Whereas an industry-wide trade group may say, yeah, we generally agree with that outcome, but we think that, you know, for this reason, and this is sort of like how we want the law to be structured. So, I mean, I could certainly say more about it, but I think that hopefully that answers the question.
Yeah, absolutely. And I think you hit on a great point at the end, and echoing something Alicia was saying, where, you know, it's not always about, and certainly at the U.S. Supreme Court level, who prevails is an important factor, but what the court writes, their opinions are what all the other courts use when they're evaluating similar situations, not the exact same situations necessarily, but similar ones. And so we have to take a broad view on what could possibly come out of these arguments. Now, let me transition and move over to Mickey, because Mickey, you in fact were up at the court and for the oral arguments here in the Goldsmith case. Tell us a little bit about that.
So, you know, the first thing is another issue that I deal with all the time and argue for is cameras in the courtroom. the fact that a very small amount of people were able to actually see this argument, I think is a real problem, because the line for the public to get in went around the block. There were people that sat out for overnight from earlier the evening before that were waiting to get in to see it. The lawyers line for lawyers that have been admitted to the court, there's a separate line. That line, not everybody got in either. And people had been there for quite a while. Due to COVID, once I got in, the space, there could have been more people in the courtroom, but they basically got people more spaced out than usual, which is interesting. But it always just bothers me for the fact that, you know, why, especially at the appellate level, when you don't have you know, a defendant that's testifying, you don't have any live testimony, you're just arguing the record, why it is that that would be so problematic. But, you know, enough said about that. It was definitely interesting being in the court. Lynn Goldsmith was there. And I was sitting not directly in back of her, but a couple of rows back. And so, you know, aside from watching the justices, you could see certain points that were being made of argument, and Lynn would either be nodding her head one way or nodding her head the other way in disagreement. It's my understanding for the people that listened, you know, thank goodness, because of COVID, the justices implemented live audio, because they used to just record it and you could hear it sometime later, not immediately, and not live. But unlike some of the arguments that have been really big ones where the television networks have decided to broadcast, and they can only broadcast obviously the audio, but at least you would see an image of which justice was speaking at the time they were speaking. I know a number of people told me they were not sure which justice was asking what question or what they were saying. All of the justices were really fully engaged. Only Justice Sotomayor wore a mask, which made her audio a little muffled. Even in the courtroom, I'm not sure how it sounded, you know, audio-wise to the people that were listening live, but they were all engaged. Clarence Thomas, who's had a reputation for never asking any questions, was very engaged, and it was only Justice Gorsuch that waited till the very end, till the Assistant Solicitor General spoke to ask a question. Again, there's very specific time for argument, as I'm sure Steve very well knows, with a little red light and a green light in front of you, and you're only allowed the time that you've got allotted. It was set for a 70-minute argument. There are 2 arguments heard when the court is in session. So this was the first case that was heard. 70 minutes. Mr. Martinez, from representing the foundation, went first because they were the petitioner. And normally he'd get 30 minutes. That part went at least 20 minutes over. It was instead, or it might have gone 30 minutes over. When I was looking at watching the clock, the arguments went 100 minutes instead of 70. And all of the questioning were on his time. I mean, obviously the justices, since they're in charge, it's their courtroom, they just get to keep going and ask all the questions they wanted to ask. And then Ms. Goldsmith's attorney spoke. She had 30 minutes. The government had 10 minutes, and we were pretty much done. But it was a very, very hot court. They were really engaged, but they also seemed to be really trying to get their arms around this whole idea of what it was they were supposed to be deciding. Fair use, even though we all see it, that term being batted around so easily, not just by lawyers, but by people who, a photographer will call them up and say, excuse me, use my picture without permission, and they'll say fair use, goodbye, and hang up the phone. It's definitely not that easy. I think many of us, especially me, and I think Alicia as well, think that the whole idea of fair use, which is supposed to be a defense to copyright, has somewhat turned copyright on its head. And it's like copyright is almost the exception to fair use now. And whether or not we're going to get that clarity that Alicia said we'd all like, it really is yet to be seen. But it's fascinating being there. I'm so glad I was able to actually get in and be there and actually watch. And hopefully one day there'll be cameras there and everybody will get that opportunity and won't have to stay out overnight. Luckily, it was a relatively nice fall day for all the people that literally slept there outside the court overnight to get in.
One thing I want to add about the timing of the argument, and then I want to have us get into the merits of the actual case. But when the United States comes in on behalf of one of the sides, the time that the United States has to argue is sort of taken away from that side. That actually happened to us in Unicolors, where the United States came in support of our client. And when they allocated the time, we had to then split our time with the United States. So we actually had less time to argue than the defendants did, which is just like, but I mean, on the one hand, you've got the United States in your favor. But yeah, and as we,
I'm sure it's nice when you find out that the Copyright Office is interested in filing a brief in support of you. So absolutely. And playing off of what Mickey just said, and then Tom, something you said earlier about the importance of amicus briefs, because ultimately what the Supreme Court says is going to make a big difference in later cases. I think getting into the merits of this case, if I may,
please.
I think the whole point of Warhol's argument, and it's a reasonable argument, is that in Campbell, I think the Second Circuit was right that Google versus Oracle didn't really move the needle. But what Google versus Oracle did is it reaffirmed a principle from the 1994 Campbell case that said that a new work is transformative and under the first prong of the fair use test if it adds something new by altering the copyrighted work with new meaning or message. And so really what Warhol came into court saying is, we put on evidence that our new work has new meaning and message. Under the Supreme Court's own words, that should have satisfied the first prong. And Warhol's like, no, it didn't. And then, answering that question and like what that means is, that's where the rubber hits the road on this case. But again, like it's all because of a particular line, in a Supreme Court decision from 1994 that we now find ourselves where we are.
Well, and so let's look real quickly at the statute that discusses fair use, and specifically the four factors that you've heard us now reference a few times. I'm simply going to pull this up, and we'll stick a link there in chat as well. And I'm not going to read the whole statute, but I am going to read these four factors that are highlighted in yellow. And so when you hear us talking about this today and in the court's questions, you'll hear them say things like factor one or factor four. Factor one says let me back up. These are the four factors that the courts use to holistically evaluate whether something is or isn't a fair use. And as has been referenced and intimated here, fair use is such a dicey and confusing situation. There is no what we call a bright line rule that says this is absolutely one thing, this is absolutely another. So these are the 4 factors that courts are supposed to take into consideration when they're evaluating whether or not something is fair use. So factor 1, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. Factor 2, the nature of the copyrighted work. Factor 3, the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And factor 4, the effect of the use upon the potential market for or value of the copyrighted work. Now, in this case, as you'll hear from some of these questions that were asked, this really drives down to 2 factors that we're focused on, factor 1 and factor 4. But even more specifically, if you remember back a minute ago when I read the question presented, in the very first little clause, it says if a work is considered transformative, right? This idea of transformative use and transformation, that all has to do with, at least in the way it was posited, a factor 1 type analysis. And so what I want to do, please.
Before you go, I don't know if you can scroll a little, but I think it's also important, besides reading the factors, to read the little preface to that section of what, kind of leading into it, because that talks again about different uses and kind of helps frame the 4 factors, and I think is part of the argument.
Absolutely.
Yeah, I think
great point. I'll be happy to read it. Yeah, go ahead.
When I look at the purpose and character of the use, which is really the question here, I look at it in conjunction with criticism, comment, news reporting, teaching, and all of those things address the purpose and character of the use. And by the way, like, news reporting doesn't mean this is an important news story and therefore we can use news photos without paying for them. What it means is, were you reporting on the work? This is what it generally means. Were you reporting on the work? Criticism, not I'm using this work to criticize something else, generally speaking, or I'm using the work to teach about something. But it's about the work. Am I teaching about the work? Because there absolutely are very huge markets in visual journalism, in academic photography, and those are massive markets, and they would fall apart if it was just I'm teaching, therefore it's fair use. And so that's, I think, one of the balances. And I think it's also interesting, if I may, when you were talking earlier about transformative, that is a very key word here. It's not in the statute. It's not in the fair use statute. And it actually is in the statute when we talk about derivative works. And I don't know if somebody else wants to expound on that, but I think that's something that the justices did talk about, and how, somehow the purpose and character of the work evolved into this question of transformative. And now we're trying to figure out what is transformative, and how does the transformative in the first factor differ from transformative in derivative use rights. And then they're adding on that, meaning and message, which also isn't in the statute. And so I think that's a really interesting, side path. And this is part of what happens when judges, interpret law, and then lawyers take from those rulings and opinions and say, well, these 3 words, are the new rule, instead of going back to the statute and saying the statute is still the rule. So I don't know if anyone else wants to add to that.
Steve, did you want to? I know you and I have had lengthy discussions about derivative works and how this impacts that. Do you want to talk about that for a second?
Sure, and I think that's a really, really important place to start. When you talk, there's no question, right? This case is a bit interesting because Warhol had gotten, or Condé Nast had gotten a license, Vanity Fair had gotten a license to use Lynn Goldsmith's photo as an artist reference for Warhol. And so in a sense, Warhol's creation of at least one of his Prince works, if not the series, was an authorized derivative work. But let's assume for the sake of argument, as happens very often, that it wasn't an authorized derivative work. Let's assume you're talking about something like, Carrier versus Prince, the appropriation artist who takes someone else's photographs and makes like new works out of them. And, the question is not, is that an unauthorized derivative or is it fair use? Because it's both. Fair use means you can take someone's work and use it for certain purposes, but it's still, you didn't get authorization and you created a derivative. And it's like an unauthorized derivative can be fair use. And so there's sort of this false claim about like, oh, well, what are we dealing with here? What we're dealing with, and that really kind of goes to the heart of the question. Are we talking about, in the Warhol case, are we talking about whether his Prince works are unauthorized derivative works, which we shouldn't be? Or are we talking about whether the use of the Lynn Goldsmith photo in those works, whether there are limitations on how that derivative work can be used? And I think it's the latter. And I think it's the latter because let's just assume for the moment that we're not talking about a derivative work. Let's say that I take one of Mickey's photographs and I want to use it in an article. There are certain uses of his photograph in an article that may be fair use. If I'm talking about, photographs taken by, people who lead artist advocacy groups, and I put that in there as sort of a representative exemplar, like that might be fair use. If I'm talking about, my trip to Paris, and I just happen to like his photograph of the Eiffel Tower and has nothing to do with Mickey, that would not be fair use. So it's not about the work or the derivative work, in my view. It's about how that work is used, right? But I think the first thing to understand, just sort of going back to Tom's initial question, is that in a case like this, it's not a question of whether it's an unauthorized derivative or fair use. It can absolutely be both. You create a derivative, and then the question is the use of that derivative in whatever way you're using it fair? And that was sort of our position that we advocated at the Supreme Court. But the Warhol position is very different. The Warhol position is no, if you've got a derivative work that's authorized, right, or that's fair use when it's created, if someone creates an authorized derivative work, they have a copyright in that authorized derivative work, and then presumptively have the right to use that copyright. Like there's really the law is just not clear on why or how that would be limited, and that's why you just start getting into sort of this messy spot, that the Supreme Court is wrestling with. I know we don't have much time.
No. I was illustrating, I think, exactly what you're talking about, which is, the difference between this image, which was licensed properly. Lynn Goldsmith's work was licensed appropriately, versus this image, which this is an exhibit from the case. On the left, we have Lynn Goldsmith's photograph, and on the right we have a different work, the one that appeared on the cover of the retrospective of Prince's life, that was not licensed. So in the initial case, 1984, we had an appropriately licensed photograph that was used as an artist reference for an illustration in the magazine of Prince. And in this example that we're looking at, we had something totally different. And I know, Mickey, you wanted to talk a little bit about this idea of the original license and then this follow-up use and all the other images that were created.
Yeah, sure. And as we said, if fair use wasn't confusing enough, and we, the people that are on this call and participating as photographers, we all know how important licensing agreements are. And yet in this case, what happened is that Vanity Fair went to Lynn Goldsmith and said, we understand you've got these pictures that you have taken of prints, and we would like to license one of them as an artist reference. They didn't tell her who the artist was, for that artist to use, which, as then Steve said, creates that authorized derivative work. And she said, sure. And she charged them $400 for it. But then the scope of the license set out certain terms that said, can't use it for anything else. It's got to be for, the person that makes this, uses my pictures and artist reference. It's for the cover of Vanity Fair, and I get a credit. So whoever the artist is, it's their name and it's my name, as having created the photograph. And that's what happened. The problem is, and the record, and it's voluminous, but it still seems to be completely devoid, and we don't have Warhol to ask anymore, as to what agreement was made between Vanity Fair and Warhol in terms of what he was allowed to do with it. And Warhol can't be bound by the agreement that Goldsmith had with Vanity Fair, or maybe she can, or maybe he can, but that's part of those nebulous questions. Is this, does the scope of the license then bind Warhol to only be able to do certain things with it? And I think that's one of the problems here, is that he then created all these other works, and whether or not one of them was authorized, or whether he created these 16 various colors and went to Vanity Fair and said, here, pick one. And then afterwards said, well, I can do something with all these 16 works now that I have. That became an issue. And then, the other part of it, and I think that was a problem, and we haven't talked about it, but factor 4 in terms of the market, I think Goldsmith certainly concedes that the artwork that was created and used in galleries and things like that, is certainly different than what was used on the magazine cover. But when they came back, when Condon Nast, 10 years later after Prince's death, said, hey, we want to do another cover, they didn't go to Goldsmith. She, was competing in that same market. They could have gone to her and said, hey, can we look at your take from that shoot that you did and use a picture of Prince for the cover? They went directly to the Warhol Foundation, because Warhol had died, and made a licensing agreement with them for significantly more than her artist reference license. And my understanding was $10,000 to use the Warhol on the cover. And there was no credit there. It was just a Warhol. So there's just so many fact-driven things that influence this, that, I think the audience really needs to understand, especially when you're writing agreements, as to who's going to get bound by them, and how they apply.
And you touched on something that ties back to what Steve was saying earlier about the use. And by the way, I think that the attorney for Warhol did a really good job of focusing on the question of purpose and character without using the word use, even though that's what that factor is about. But, the question of, what Warhol can do in his studio, in private with this work, making silk screens and making art, and then he didn't even really display it. And so, was the creation of that work and was hanging it or putting it in the closet, basically, or even if he hung it on the wall in his living room, right? That's a much different use than the use in the magazine that was directly in competition with Goldsmith's own images. And so that ties back into this question of, it's the use that matters. And there can absolutely be one use that is infringing and one use that is fair use, or rather one use that is infringing and not fair use, and one use that, and I'll give you a perfect example. Like a few minutes ago, right, Tom put up this side by side, right, and so that's Lynn Goldsmith's photograph, and we did not ask her first, frankly, to be honest. At least I didn't. I don't know, maybe you did, Tom, but but we're absolutely talking about, commenting on, critiquing, something about that work. And so, that use is significantly different than we want to illustrate a story about Prince. And so we're going to use this image.
I think,
so
yeah, go ahead.
We all generally agree, I think, on this call to that, but I think the view of the Warhol Foundation is that really that doesn't matter. The view of the Warhol Foundation is that under the first factor, under the Supreme Court's language from Campbell, if there's new meaning or message in the work created, it is transformative and thus satisfies the first factor of fair use. And so, assuming that when Warhol created his artistic, versions of Prince using Lynn Goldsmith's photo, there is new meaning or message. That is a fair use that he's now free to use however he wants. That's their view. So all these questions of the scope of the license are, they would say they're interesting academic questions, but they don't matter, at least under the first factor, because Warhol created a work that is generally understood to have new meaning or message. Well, what's that meaning or message? They're going to say, well, when Lynn Goldsmith took her photo, it was before Prince had achieved all this celebrity. It was before Purple Rain. It was when he was, he was like almost like shy and vulnerable. And then Warholed him, like he did his Warhol, and made him into this larger than life pop figure, which is very different from this shy, it connotes a different message. And so all of the rest of it is, under their view, I think, is nonsense, because it's transformative. It conveys new meaning or message. It's therefore, at least under the first prong, fair use, and thus the Second Circuit got it wrong, at least in saying that all four factors favored Lynn. And then that's the question. That, like, what does that mean? What does that Supreme Court language from Campbell mean? What did they mean when they said if there's new meaning or message, it's transformative under the first, and basically to satisfy the first prong? What does that mean?
And where do you think the justices were going with that question, Stephen? I mean, where do you think which side do you think they tended to fall on it? I was very optimistic listening to them talk, particularly with Thomas's hypo. That was really a fun conversation that we had amongst ourselves, as we were writing the brief.
Yeah, I was as well. And no one made the argument that I wish someone had made a bit more clearly. And that argument is that, and it's kind of the argument that we made in our amicus brief, which is that there really has to be a fundamentally different use before meaning or message becomes relevant, right? If I'm going to take, and there's a lot of discussion about movies, about how like someone will write, a book, and that book might then be adapted into a movie. You could say that a movie is a fundamentally different use of a storyline than a book or whatever it is. If you take the book, you convert it to a movie, and it doesn't really have a different meaning or message, there's no question it's not fair use. You've just made an unauthorized adaptation. I think that when you look at cases like Campbell was a case involving parody, right? It wasn't one song, someone taking a song and using it to create a new song that was going to be a market substitute, or that was going to kind of supplant it was a parody that had to use the original. There's a reasonable need to use it inside of something that literally, falls under classic fair use of education, parody, like those things. You've got a fundamentally different use. And so then you're going to look at whether there's a new meaning or message, and then you're going to make your fair use analysis. If it's not a fundamentally different use, and really, again, this is what we argued in our brief, if you're saying, okay, you've got a great portrait of Prince, I'm going to create a different artistic portrait of Prince using your portrait of Prince, like it's not, you're not really transforming what the work is. And even if you put some, and I think even if you put some new meaning or message into it, like that's literally your classic derivative work. And a copyright holder has the right to control, the creation of derivative works based on their work. So, I think the conversation that I wish someone had had with the Supreme Court was like, look, Your Honors, obviously your language in Campbell was correct in the context of Campbell, in the context of a parody. If you're taking a parody and it's like, it's a reasonable person would recognize this as a parody and there's new meaning or message, great, you've got fair use. If, the Warhol picture is not a parody of Lynn Goldsmith's photo. It's an artistic rendering of Prince, and it's another artistic rendering of Prince. And they literally, as Tom indicated, were competing for the same magazine covers, like for the same licensing market. Like, I think there has to be a qualitatively different use before meaning or message becomes relevant. And so, in that sense, you want to kind of clarify and maybe even cabin in a little bit the Supreme Court's ruling in Campbell. And I think that's what at least some of the questions we're getting at is like, how do we square this? How do we square the language of Campbell with, and I think the Supreme Court was very receptive to the arguments made by a lot of the amici that, if you literally say anytime you put any new meaning or message into an unauthorized derivative work, you satisfy the first prong for fair use. Fair use starts to swallow the right of the copyright holder to control the creation of derivative works. Like the exception starts to swallow the rule, and that can't be the case. So what should the rule be? And that was a big part of the conversation with the United States is what exactly are you proposing for the rule? And that's what they've got to wrestle with.
Well, I think that's the perfect lead into let's look at what the justices were asking and look at their language and have some discussion about that. And I will tell you the transcript is 133 pages. We are not going to go through each of the 133 pages, but there are some things that that I've picked out that I think echo what you just heard from Steve and Alicia and Mickey. And so very early on in the argument, within the first few minutes of the argument, after the Andy Warhol Foundation's lawyer had given his outline of a few of their main points, Justice Sotomayor said, I read factor one, the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. So what's the use here? I think I have to look at a use under one as well. So is the use the creation of the print series by Warhol? Is it the 2016 license of the Orange Prince? That factor, I think, is telling to me to look at a use. So which use are you looking at? Now, I'm going to skip down a little bit. And there's, when you get these transcripts that are actual literal transcripts, it's not quite as clean as you might see otherwise. But Justice Sotomayor finally comes around with Mr. Martinez, and she says, but let's look at the 2016 license of Orange Prince. So here is one of the first times that the Andy Warhol Foundation, in response to this idea of what's the use and what are we actually looking at here, Mr. Martinez, the Warhol Foundation's lawyer, says, even with respect to the licensing use, you'd still need to look at factor one, which would look at the purpose and character of the use. And that would certainly encompass the fact that Warhol's use, the image that's being licensed, was transformative and created and infused a new meaning or message on top of Goldsmith's original work. Justice Sotomayor, it comes back and looks at this a little differently. And she says, but then what do I do with the rest of factor one, the purpose of the use and the character of the use? Because that's not just up to the author. That's up to what was made of Orange Prince. It was a highly commercial use. Goldsmith also licensed her photograph to magazines, just as Warhol's estate did. So how is it that your 2006 license and Goldsmith's photographs do not share the same commercial purpose? And then this is the last little piece on this. And then I'd like to get some thoughts from you all on some of these elements. Mr. Martinez says, it's true that there is a commercial purpose, and so that might be a factor that would cut against us when assessing factor one. You know, as I look at this, you know, we have Justice Sotomayor who's getting to the heart of what we've all been talking about here right at the top. But I want to focus a little bit on what Mr. Martinez for the Andy Warhol Foundation said, and that is that Warhol's use, the image that's being licensed, was transformative and created and infused a new meaning or message on top of Goldsmith's original work. Now, you know, I think this is one of the flashpoints, right? And we're going to see some questions later that talk about, well, who gets to determine what's new meaning or message? But that exchange there with Justice Sotomayor, any thoughts on that? Any comments you all have?
Well, I think, you know, she's worried about that kind of the same thing that the government was worried about, same thing that we're worried about. Like, if they adopt that view of factor one without, as you know, Stephen said, what's the use, then pretty much everything becomes fair use. You know, and that makes absolutely no sense. That you need to, you know, to look at the reason the Congress put in 4 factors and put in, as you know, we were going to try and read some of those uses before they got to the factors. It's got to satisfy that, you know, parity. Again, as Stephen said, you can't have parity without having the original to kind of make fun of. And in this case, you know, the argument is Warhol could have gotten any other pictures. I mean, could have gotten this brilliant idea, like after he made this artist's work for the cover, then went on to say, you know what, this gives me a great idea. Let me do something with Prince, take my own picture. Hi, I'm famous. I'm Warhol. Can I take your picture? I'd like to do some work with it. Or other pictures, or gone to Lynn and said, you know what, it gave me an idea. I really love the fact that I was able to do this. I'd like to license that image that I had as an artist reference to create these other works from. Because Lynn could have done the same thing. She, you know, she held a copyright in this, and she could have looked at it and said, oh, that's an interesting way of dealing with my picture. Well, maybe I should just colorize them and use this process and figure out another use for it. And that's what you're entitled to when you own the copyright.
Right, that's the derivative work right that we've been discussing. Let me, you know, let me skip ahead just a little bit to something Justice Alito said, because I feel like Justice Sotomayor has echoed so much of already what we had put in our brief, but Justice Alito just a few moments later brings up a question that is a tough question to answer, and one that I think comes up a lot. Justice Alito says, how is a court to determine the purpose of meaning, the message or meaning of works of art like a photograph or a painting? Should it receive testimony by the photographer and the artist? Do you call art critics as experts? How does a court go about doing this? He continues, after, you know, Mr. Martinez was talking about, well, you know, there are traditional ways that this happens in trial court with experts. Justice Alito says, you make it sound simple, but maybe it's not so simple, at least in some cases, to determine what is the meaning or the message of a work of art. There can be a lot of dispute about what the meaning or the message is. Some people would say it's not necessarily the meaning or the message that the artist had in mind. And then Justice Alito says, I don't know, if you called Andy Warhol as a witness, what would he say was the purpose of his and the message or meaning of this creation? Now, that goes to this idea where, if we're looking at the Warhol Foundation test that talks about adding new message or meaning, it begs the question that Justice Alito asked, which is, well, how is a court supposed to figure out what is considered new message or meaning enough that it now becomes a work subject to a fair use defense? What do y'all think?
I think, they touched on this in their responses and I think we've seen this in a lot of courts. Judges don't want to be the arbiters of the meaning of art or the message of art or what constitutes art. They don't think that's the appropriate place. And I think, some artists don't publicly ascribe any meaning to their art, and they want it to mean something different to everyone who views it. And that's a very valid and important way of treating your art. And so that gets into a lot of really philosophical questions about art itself. And boy, that's, if that's what we're left with, that's going to be so tough. And I see Steven smiling.
Yeah, no, totally. I mean, this is exactly, I think, what I was just talking about the fair use exception swallowing the derivative right rule. If all you have to do is take something and change the color of it, because I made it purple, and purple denotes royalty, and therefore now there's new meaning or message, or I made it red and everyone knows red means angry. So like you've taken someone's work and just added some different color. Or sometimes, God, what was it? There was something I saw like years ago about someone like selling some like 4-year-old artwork as like fine art, and people like falling for it. It's like, oh yeah, I see the chaos of the world, and like all of the stuff that you're gonna like, read into it. Like, of course, like meaning is in the eye of the beholder. It's a subjective thing. And, you want the law to be more objective than that. And you want to make sure that you're adequately protecting people's rights to control the ability to, to use their work to create derivatives. Like they have a right to, control derivative works outside of narrow exceptions. And that's what the court's dealing with here. The court's like wrestling with, okay, how, at the risk of repeating myself, how do we have the exception not swallow the rule?
Right. So, well, let's talk about that for a second. And I'm going to skip ahead a little to something that Lynn Goldsmith's attorney brought up when she was being questioned. And it was, so over here on one side, we have the Andy Warhol Foundation test, which relies heavily on the idea that just adding new meaning or message necessarily, transforms a work, and therefore under factor one, it's more likely to be fair use. But then, when asked to state the test that Lynn Goldsmith is looking at, went in a different direction, not necessarily on this point particularly, but one that I think is important so that the viewers know kind of what the competing issues are. Lynn Goldsmith's attorney, Ms. Blatt, said, yeah, so let me just state our test. When the defendant has an asserted purpose for copying someone else's work, you ask, was the copying of the original needed to best achieve the copier's purpose? So was the copying of the original needed to best achieve the purpose? That brings up the question we had in the Q&A that I wanted to just pose to the group. And the question is, can you speak to the concept of needing the image and being allowed to use it for free when the option is there to license it and the artist in question certainly had the capacity financially to do so? And so when I look at what the court is talking about and what this question is, and that is, even under Goldsmith's test, I think there could easily be some confusion about needing, this idea of needing a work. I will go back quickly before I open it up to the group and to something Alicia was talking about earlier, which is, the different purposes where you might use a copyrighted work when you are critiquing or commenting on the specific work at issue, not just using the work at issue as an illustration around some other topic. And so what does needing mean? Even in Lynn Goldsmith's test, what do we mean by needing?
Well, I think what you said is exactly right. I mean, when you're critiquing a work, or when you're reporting on a work or some kind of controversy surrounding the work, like some of the cases we cited in our brief, you need the work. In other words, you can't communicate that critique or that reporting without showing the work or using the work in some way. Whether that's a summary of a book plot, or a particular photograph caused a huge controversy, and therefore you have to show at least some of the photograph to highlight the controversy and help people understand, in those cases. And, you need the work. And that's why I always, when I talk about fair use, recommend that people focus on exactly what you said. Is it about the work? Is it relate, does your work relate to the work, as opposed to just being needing the work, like, because it fills the hole that I want to fill.
And this actually dovetails right into this piece, and I think it adds a different layer. Justice Kavanaugh says, in a story about the subject of the photograph, such as the story that was used here, the subject of the photograph was Prince, the story was about Prince, how is that not superseding the object of the original photograph? And the lawyer for the Warhol Foundation says, so it's not because it has the transformative meaning or message. It would have sent a different message to use the Goldsmith photograph illustrating that article. Well, that seems a little circular. I mean, if are we saying, that it's not superseding because it has a different meaning or message? That takes us back to that idea of how are we ascertaining meaning or message? Any comments on that argument? And maybe Steve, I know you had mentioned a little earlier, putting on the hat of Goldsmith's attorney for a second. And when Goldsmith's attorney says it's not superseding because it has a transformative meaning or message, it would have sent a different message to use the Goldsmith's photograph illustrating that Purple Fame article. What's your take on that?
Yeah, so I think what they're saying is that, after Prince had died, they're doing an article on Prince, and the message that article is trying to convey is that Prince was larger than life, that he was this mega celebrity, and they're using the Warhol image that conveys that rather than the Lynn Goldsmith image that they've characterized as him being more shy. And, if you're doing an article on, what an amazingly humble guy he was, there's a photograph that sends that message. If you're doing it, so I think that's the argument they're trying to make. I don't buy it, but that's the best that I can reconcile, his answer, with what I understand their argument to be.
Well, jumping down. Sorry, go ahead.
I said, I guess we need a Justice Doniger up there. I wanted to touch a little more on the question about needing the work, because they did bring up an interesting problem, but I don't see it in the same way that that Goldsmith's, that Warhol's attorney saw, which is that why pick that particular photograph, and they were saying, well, you needed some photograph of Prince, and so she just was the unlucky draw, essentially. Although first of all, that's just not true in my opinion. Like, there are reasons why people choose photographs and use them when they infringe, and it usually has to do with them being great pictures. But their point was, and they harkened back to the Campbell Soup artwork by Andy Warhol, that if he's going to talk about commercialism, he has to use something, whether it's Campbell's Soup or Cheerios or something. Someone's going to draw the short straw and be the product that is stuck in this work. I'm interested to hear what the rest of you think about it. I think that is, again, just, I'm too lazy to go get it. I don't want to license it, but I need it, which is, it's just not what fair use is for. And if you need something, that's why there is licensing.
But playing off that, Campbell's Soup created that can of soup to sell as a product. and they might have used images of it to market it, to sell to people, but I don't think any of them ever thought of it as artwork. And so when Warhol did something else with it to comment on commercialism, it really was a different purpose and meaning. And I don't think, that the Campbell Soup Company would have come back and said, and even if they did, probably would have lost the argument of, well, wait a minute, this is a copyrighted. It's like, no, I took something that you never in your wildest dreams thought about. Certainly it's a different market. And that's where, again, factor 1 and factor 4 are so intertwined, because we're, as we've all said, and everybody is saying, even the foundation's lawyer, well, it was, that might have been different if they wanted to use it to show something else. It was the market of the magazine cover. It was the same market. And I think, that's the big difference here, is that, there's nothing to say that the genius of Warhol in doing certain things went well. But I think in this case, the problem is, and I think that was in the question, shouldn't he have just gone and said, hey, can I have a license to do something more with it? I've got this great idea. And I think that's what we're all talking about, and what we tried to convey in our brief, what the government tried to convey in its brief, is that in order for photographers in particular to continue to earn a living, they have to be able to license their work. And if this different purpose and meaning, message and meaning is able, plays out, then everybody will be able to just take any image they want and say, well, you used it for this, but I want to use it for that. And, to me, it's just transforming it from making money for the person who created it to transforming it to making money for the person who's now using it.
Yeah, I think the Campbell soup can example is a really, really good one to demonstrate what we were saying earlier, that it really has to be a fundamentally different use before meaning and message becomes relevant. But I also think that the Campbell soup can points out the problem with the need argument. And I think it's an uphill battle to argue that a need-based test is the appropriate test, because no one's going to say that Warhol needed to use Campbell's soup can necessarily. He had to use something, but it didn't have to be the Campbell soup can. And so when you start applying a need test as a basis for fair use, there are going to be a lot of situations in which you're going to have trouble.
Right. I think, go ahead.
I'm sorry, but couldn't, the argument be that because Campbell's soup is in a way so iconic to represent commercialism, at least back then and in his mind, that's what it represented, and that's what he was trying to comment on. So maybe he could have taken some other iconic thing, as Alicia said, a box of Cheerios or something that everybody recognizes, as opposed to taking some obscure product and they go,
Coca-Cola, Pepsi.
Yeah,
Times.
exactly. Could have done any of those things.
Absolutely.
Noticing this interesting question in the Q&A about is the crux that both people could use the photo or art in the magazine. And that's certainly part of our argument. But, to the end of your question, is it okay to make and sell art based on her work if it's, art? I think that goes to an issue that we have addressed before and didn't really focus on in this case, but that, and that's partly because, this case didn't really focus on the fourth factor, which is the market. But that question, I think, really, that's one where in some cases they've said the fourth factor is the most important factor, except when they decide it's the first factor. The market, the interference with the market is such an important question when you talk about fair use. And this is really deviating from the conversation that we've been having, but in this webinar. But I think it's really important that we don't just think to ourselves, she had a market with the magazine and therefore they can't interfere with the magazine market, because photography has such a broad potential market. And just because you haven't used your work or offered your work in a certain market doesn't mean you're not planning to,
Not going to.
put in or not going to. And so one of the things that we really look out for when we look at these cases and decide when to weigh in on things is ones that address that very question of, this is not the market where that photographer was operating, but it's a market where the photographer could have operated. So even if it wasn't a case that was, magazine use versus magazine use, it still could be that she absolutely had a door to that market if they would have just licensed it from her. And therefore, it matters.
Yeah,
I think yeah, go ahead, Steve.
Go ahead, Tom.
No. I think that's a critically important point, and without diving too far down this rabbit hole, these works from Lynn Goldsmith were unpublished works, and one of the things that you get to choose as the owner of a copyright is when and how you disseminate the work that you create. That's one of those rights that is granted to you, and so there's an additional level of not only is it markets that someone has clearly established themselves in, it's potential markets that they may work in the future, and the impact of this on all of those markets as well. And again, as Alicia alluded to, Factor 4 came up a lot in this oral argument for a case that was ostensibly solely going to be a Factor 1 type case. Steve?
Yeah, I mean you're kind of echoing what I was getting at. I think great minds think alike. Now, you know what? I think you've had.
Okay, perfect. Well, let me jump back to one thing that we teased earlier that I think is worth talking about, and that is this hypothetical situation from Justice Thomas. And so here in an exchange, a lengthy exchange, but an exchange, Justice Thomas says, well, he starts by saying, let's say that I'm both a Prince fan, which I was in the 80s, and then of course in the transcript there's laughter, and Justice Kagan says no longer. They had a little sideshow going on back and forth there, okay? But let's say that I'm also a Syracuse fan, and I decide to make one of those big blow-up posters of Orange Prince and change the colors a little bit around the edges and put "Go Orange" underneath. Would you sue me? The transcript there, Mr. Martinez's response would, and then Justice Thomas says for infringement. Would you sue me for infringement? And after a lot of back and forth, it comes to this idea. Well, Mr. Martinez says, well, it's not really, you're not using it in a commercial way. And Justice Thomas says, no, I'm going to market it to all of my Syracuse buddies. I am going to do it in a commercial way. Mr. Martinez continues and says, well, I would not sue. I think that you'd have a weak case against me. And then Justice Thomas says, so then you've changed position with Goldsmith. Mr. Martinez says, no, not at all. Because in this circumstance, I think this is totally different, because there's a transformative meaning or message, and there's an enormous amount of creativity. Well, that's, I am not an art critic, right? I don't proclaim to understand all of the things that Warhol is arguing here. But let me look at Justice Thomas's example, where Justice Thomas says if he takes the image on the right and writes "Go Orange" below it and changes the color maybe a little around the edges, Mr. Martinez argues that the case with Lynn Goldsmith is totally different because there's a transformative meaning or message and there's an enormous amount of creativity. So looking at the difference between Lynn Goldsmith's original photograph and Warhol's orange prints, and then looking at orange prints to Justice Thomas's hypothetical, Lynn Goldsmith's attorney is arguing that there's an enormous difference, an enormous amount of creativity. What do you all think? And who gets, is this the crux of the problem, that there's a line in here somewhere, but we all don't know where the line is, right?
Yeah, and I think one of the other problems is, and we see it in other cases, is where people question the copyrightability of a photograph, especially a news photograph. Like, well, how much creativity went into the photograph? You just took something in the real world and captured it. You didn't direct them, because as news photographers, we're not allowed to tell subjects where to move or how to go. And, you know, our argument is there's a lot of elements that go into that. What type of film you're going to use, what lens you're going to use, where you position yourself, all of those things. But I think that would cut against, you know, the way you pose the question. When you look at what Warhol did with Goldsmith's pictures, you can make an argument there as well, as how, other than the fact it's a Warhol, how much creativity went into it. It's basically this very mechanical process that, it's my understanding, he didn't even do. He has it done by, kind of had it done by his minions at his factory. You know, it's a silk screening process, projecting the image. And so they did a little outline and they threw some orange paint on it. And so how creative is that? So I think you start to go down that road and it becomes a real problem.
We're back to the question of, you know, judges interpreting meaning and message in art, which I think we didn't really want to do. That hypo by Justice Thomas, for those of you who, most of you probably aren't in the legal world, got a lot of love in the world of attorneys who, you know, have spent years watching Thomas not say much at all, and then have such a fun interjection from him. Got a lot of.
Well, what I want to do here is we're coming to the end, and I just want to do some quick hit additional arguments that were in the opinion. Obviously, we spent 90 minutes on this. I think collectively the four of us have discussed this case for if not hundreds of hours, pretty close. And I think there's a lot more to be said, and so I encourage you to one, if you're not a member of organizations such as NPPA or APA or ASMP, we definitely encourage you to be, because you have people like the four of us fighting for you at all different levels, and fighting for the rights of creators, both on the side to use works under an appropriate fair use framework, and for those whose works are used, right? But I want to just hit a few other arguments, and then maybe just get some quick reaction thoughts before we end for today. And thank you for the questions that have come in. I know we're not going to have a chance to answer them all, but this stuck out to me, and it hasn't gotten much attention. But I just wanted to see if anyone had the same kind of thoughts that I had on it. And Justice Kavanaugh says to the Andy Warhol Foundation's lawyer, in 1984, originally, did Vanity Fair need to pay Goldsmith? Remember that they did pay Goldsmith the license fee for the artist reference work that Mickey was describing, that included attribution and all the other pieces of it. And the Andy Warhol Foundation's lawyer says, no, Your Honor, I don't think they needed to pay. Does that change anything that we've talked about? Do you think that this is in line with the line of arguments that the Warhol Foundation is going with, where the use, the creation, where essentially the fair use determination is baked in to the work at the moment of creation versus any future use, or did that just kind of appeal to me?
No, what I found really interesting about that question and answer is that at the time of the license, they didn't know what Warhol was going to create. They didn't know whether Warhol's artwork was going to carry some new meaning or message. They didn't know what that meaning or message was. And so the only way, it just seems to me, and just think about this for a moment, the only way you can say they didn't need to get a license and pay her, because it would have been fair use, is if you think that the creation of a derivative by another artist is automatically fair use before you have any idea what the meaning or message associated with the new work is. Like, that's crazy. And I think it's telling.
Yeah. I want to, and this may be one of the last things we cover, and we haven't given it any time at all, and that is the fact that the government, and in Supreme Court cases, the government always has an opportunity to enter the case and give their 2 cents on it. And it doesn't, I think it's fair to say it doesn't happen often, but it has happened in, I think, all the recent copyright cases, including Unicolors, and in this case as well. And so when the government weighs in, they're weighing in on behalf of the Copyright Office and kind of establishing what the government's position is, which doesn't always exactly track with one party or the other party. But I thought it was worthwhile to look at the very beginning of the government's argument. And it was 2 questions drive factor 1. Does the use serve a distinct purpose or instead supersede the original? And what is the justification for copying? So the government here, in literally in 4 lines, in the first 4 lines that they argued, said the 2 questions are: does the use serve a distinct purpose, or instead does it supersede the original? And what is the justification for copying? I mean, that's fairly substantial. That tracks very closely with what Lynn's attorneys were talking about with this idea of a need argument. A little different though. Justification, establishing a justification is different than having to prove need, but still the idea remains. Just very quickly in the last 2 minutes that we have, whether you want to talk about that piece of it or any other piece of it, what do we think? What do we think about the government weighing in, and do we think that's going to be influential with the court?
I think it's certainly going to be. Oh, all right, not certainly. I'm hopeful that it will be influential with the court. Interestingly enough, I got to talk to Ms. Dubin afterwards, and you know what she said was interesting. Is that because if you look again at the transcript, they said, well, what would you like us to do with the Second Circuit opinion? And she said that we'd like you to affirm it. And had they just wanted to affirm it, as in most cases where there's a petition for cert, all they had to do is deny cert and the ruling of the Second Circuit would have stood. So clearly the Supreme Court wants to do something else. You know, don't know what that is. I think it might be remanded back. But it was interesting that she wanted them to affirm that, and yet the Supreme Court could have done that very easily without arguing about anything by just denying cert.
Yeah. I noticed that their brief talked a lot about the points that we made, which was, you know, the focus on the use. And one of the thoughts I had before oral argument was, if the justices talk about the use question, you know, there's some hope that they get it. And if they hadn't talked about it, I would be very pessimistic. And I think that one thing that the government did contribute by participating and by weighing in was that focus on the use. And I really think they brought attention to that question in a way that, you know, might not have happened had they not been a part of it.
Well, let me wrap up today, and first of all, thank Alicia and Mickey and Steve, one for working on this brief so diligently. it was certainly something that we all feel very passionately about. And as a creator, I want you all to be thinking about the role of this case and its upcoming determination and what the opinion might read like when we get it, likely here in the spring. Because what Lynn Goldsmith is doing here is fighting a fight for a lot of different people, including photographers and videographers and creators, like many of you all. And that's always something I've kept in mind since Lynn and I first talked about this case, I think back in 2017, 2018 or so. And as we've seen this case move through the ranks, we've seen lots of arguments from both sides. One of the argument that the district court judge made, which essentially was, well, if Warhol did it, then it's necessarily transformative because Warhol has a distinctive style, and that was roundly dismissed by the Second Circuit, and I think importantly so, because as you've heard from all the different speakers here today, the idea of fair use is nebulous on the best of days, and to live in a world where just simply saying or implying that something might have a new meaning or message, therefore makes it open season and for fair use purposes. I think all of us are very concerned about that day. But let me also say that all of us understand that creators of all stripes, including photographers, use pre-existing works in their works. And it's important to have a fair use framework that is one, fair, but two, clear. I'll go back to what Alicia said at the beginning, which is getting some clarity on this issue, I think, is one of the most important things that can come out. It helps everyone understand what the rules are. And right now, we live in a world where, depending on what state you're in or what court you're in or what judge you're in front of, you may have the exact same case come out in different ways. And that's obviously what the law is always trying to avoid. I want to thank all of you for attending today, and check your emails where you'll be able to find a replay of this webinar. And thank you all very much, Steve and Alicia and Nikki.
Thanks, Tom.
Great job, Tom. Thank you. And thank you to all the panelists.
Bye now.